Ready? Absolutely. All right. Next is Senator Jackson with SB 686.
Mr. Chair, this is for clarification. Is this not a reconsideration because it did not fail? What is the procedure on this? Because we did hear this before. Is it a representation or?
The bill before you, we didn't take a vote. We didn't take a motion last time.
It was essentially pulled.
We had testimony, but it's been amended since.
Good afternoon, good morning. Feels like afternoon. Feels like Thursday, doesn't it? But anyway, good afternoon, Mr. Chair and members. To respond to Mr. Hagman's observation, we were asked to hold this bill pending a decision by the federal government, NHTSA, on how they wanted to address recalls and notification. And subsequently, the federal government has indicated that the way they want to handle this issue is to allow, or is to require, I should say, that manufacturers who have recalls of their vehicles are required to post them on their websites so that they're available to the public and to car dealers and to others. So that resolved that issue. There was a question about whether they were going to have their own website, their own posting, but they said no, every car manufacturer is going to be required to have a website and to post that information on the website. That resolved that question that many of the members were concerned and felt that the bill was premature pending that determination. So here we are today. Since the 19th, and I want to thank my colleagues here who patiently listened to the concerns on both sides of this. I would hope that they will also continue to maintain an open mind as we proceed. We have witnesses here who are going to testify and answer perhaps some of their questions. But since the 1960s, federal law has prohibited franchised new car dealers from selling new vehicles that are under a federal manufacturer's safety recall until the repairs have been made. That has been the law since the 60s. Some of us remember those days. SB 686 would extend this same prohibition to the sale of used cars. It would prohibit car dealers, including rental car companies that sell used cars, from selling or otherwise transferring ownership of a used car under a federal manufacturer's safety recall to a retail customer, that's you and me, until the safety recall repairs have been made. The impetus for this bill is the serious and ongoing problem of California car dealers selling unsafe, recalled used cars to consumers without first getting them fixed. This problem has been well documented in the media nationwide and by numerous major news organizations in our own state. While many responsible, ethical car dealers do not engage in this kind of reckless behavior, unfortunately others do, from new car dealers to corner car lots. They have been repeatedly and on camera, I might say, been caught selling cars that place their customers' lives in jeopardy and endanger the lives of their passengers and, frankly, everyone else on the road. When these cars deteriorate in front of our eyes, and we have people here today, and we've had in the past, people have testified about these circumstances. When a car's steering mechanism fails and you happen to be in the next lane to that person and the car actually then comes into your lane, that is an accident that happens, and injuries and deaths have occurred. Last year, this bill was held in committee, and as I mentioned, since then a lot has changed. Last year, the opponents had argued because the bill was premature. We dealt with that. In August, NHTSA issued its ruling. The dealers had predicted that the agency would create a new centralized database, but in fact, NHTSA said that a centralized database was unnecessary and would be duplicative. The new rule takes effect this August 14th. If this bill is enacted, it will take effect January 1st, 2015, and the NHTSA rule will be in full force and effect by then. And when that happens, no dealer will have any excuse for not checking the recall status of a car and getting it repaired before putting the keys into your hands or my hands or our constituents' hands. In addition, I've taken all of the amendments that were recommended by this committee in last year's analysis and then some. One of the most significant issues raised at last year's hearing was that the bill exempted rental car companies regarding their rentals because those transactions are being addressed by federal legislation authored by Senators Schumer, Boxer, Feinstein, and McCaskill and supported by the rental car industry that's going to affect them in the rental of cars. But it's been opposed by the car dealers. I'm not sure that makes sense, but that is the fact. This year, I've amended the bill to eliminate the rental car company exemption for rental cars that they sell. Now, this bill will apply equally to all dealers, including rental car companies, regarding the sale of their used cars. This is now a level playing field. If you are a rental car company and you are selling your rental car, you will be under the same requirement as a car dealer when he or she sells you a rental car. Level playing field. The interesting thing I might point is that the rental car companies support this and actually have been doing this in the over 20,000 cars that are sold each year by a rental car company in California. They check and they fix if there is a manufacturer's recall. The only obstinance at this point in time is the car dealers. The amendments also clarify that the bill allows dealers to sell recalled used cars to other dealers, to auto auctions, or other wholesalers. It only prohibits them from selling them to retail consumers. So if a dealer has a recalled car on his lot and he doesn't know, and I say he as he and she rather than go through that, it's hopefully a gender-neutral statement. But if they have them on their lots and they don't want to wait for the repair parts, they can sell it to another dealer. Some dealers actually welcome the repair business if they are authorized by the manufacturer to perform the repairs, because the manufacturer is required by federal law to cover the entire cost of repair. So if you are a car dealership, you have that repair facility on your lot, you get 100 cents on the dollar. It's a moneymaker, which is why the machinists support this bill and estimate it's going to add 1,000 new jobs out there, because car dealers are going to be able to do those repairs and get 100% of the cost. Under this bill, what would not be legal would be a dealer doing what a major franchised new car dealership did in Visalia just this last July, just days after this measure was held in committee. That dealership sold a fellow named David Clayton, who was here last year. He's a husband and father of 3 who works as an IT specialist. Sold him what he bought was a certified 2009 Dodge Ram. He told us, and unfortunately he couldn't be here today, he bought a certified car, paid more money for it because he expected that they had done all the bells and whistles that a certified car claims to address. The dealership claimed it had passed a rigorous 125-point inspection. They even handed him a checklist that indicated all of the manufacturer's service campaigns had been performed, including safety recalls. But in reality, Chrysler had recalled the truck because it had a safety defect. The drivetrain was prone to separating from the rear axle, causing what Chrysler said was a risk of a crash. And while the dealership knew about the recall, they failed to fix the truck. A few months later, when he was driving on the freeway near his home in Fresno, going at about 65 miles an hour, suddenly the truck literally fell apart. He lost the steering, the drive shaft slammed into the gas tank, and thank goodness the truck didn't collide with another vehicle or explode into flames. He got out of the side of the freeway, called his wife, who checked online, and found out the truck was under a safety recall. He called the dealer who sold him the truck and was told that they hadn't fixed it because there was a delay in getting the parts. Needless to say, he was not a happy guy. He took the car to a different dealer to have the safety recall repairs performed, and that dealer fixed the truck within about 2 weeks, including replacing the damaged gas tank. He later found out that the dealer in Visalia had the truck on its lot for months. for months before selling it to him, but just didn't bother to make the repairs. He's a very lucky guy to be alive, and he recognizes that fact. That should be illegal. Under this measure, it would be. As I mentioned, I met Mr. Clayton and one of his daughters. They didn't think the dealer's excuse about a shortage of repair parts was any justification for selling him a product that they knew was unsafe. And I hope you would agree. I've also amended the bill to define what a manufacturer's safety recall is. It clarifies that the bill does not apply to non-safety related defects, so-called service campaigns for such items as air conditioners that don't work or emissions recalls. I understand there might be some confusion about whether there is such a thing as a minor safety recall, but the answer is no. If it's unsafe, it's unsafe. And according to the National Highway Traffic Safety Administration, which oversees all these recalls, it says all safety recalls resulting from defects present an unreasonable risk to safety. And we believe it is inappropriate to suggest that some defects are not risky enough to require repair. For the safety of the motoring public, all recalled vehicles should be fixed promptly. Even one of the opponents of the bill, CarMax, says in its letter of opposition, quote, manufacturers' safety recalls should be taken seriously by manufacturers, dealers, and consumers, which is why CarMax carefully advises its customers to register their vehicles with the manufacturers as soon as possible so that the vehicle can be apprised for future recalls. But we're not looking at future recalls in this bill. We're looking at ones that exist before that car is put in the hands of a consumer. Unfortunately, what CarMax fails to do, as I mentioned, is to address the past recalls as if they were less serious than future recalls. Members, all I am asking you to do is what is already considered a best practice among many auto dealerships in our state, that we apply these standards across the board so that Californians who buy used cars have the same level of protection from unsafe recalled cars that is already enjoyed by people who buy new cars. And this levels the playing fields for dealers who have already adopted these safety practices, ensuring they aren't at a competitive disadvantage because they refuse to sell unsafe cars. That should be what every car dealer does. And according to the machinists I mentioned, they believe it will create 1,000 new jobs. I'll close with a quote from retired California new car dealer Salvatore Cerrito, who was here last year. He has since moved out of state and wasn't available. He said, I owned and managed major new car, I don't have his New Jersey accent and I'm not Italian, but if you can imagine. I owned and managed major new car franchised auto dealerships in Northern and Southern California, including dealerships for Chevrolet, Pontiac, Cadillac, Oldsmobile, Lincoln, Mercury, Chrysler, Jeep, Dodge, Toyota, Honda, Nissan, Mitsubishi, Hyundai, Saab, Rolls-Royce, and Bentley. During that time, I ensured that the safety of our customers was paramount. I established procedures for performing routine inspections on all the vehicles we offered for sale, including a check to identify vehicles with outstanding safety recalls, and either get them fixed or sell them at wholesale, rather than putting my customers' safety at risk. I have some witnesses here today to testify, including the sponsor, Rosemary Sheehan, who is the president of Consumers for Auto Reliability and Safety, otherwise known as CARS, who is best known for initiating California's landmark Auto Lemon Law, which became the model for similar laws in all 50 states. And Damian Snow of Beverly Hills, who was 18 years old when he was sold a recalled PT Cruiser with a recall pending for a safety defect that is the exact same defect that killed two sisters, Rachel and Jacqueline Houck, who were 20 and 24 years of age. And their mother, Kathy Houck, is a constituent of mine who lives in Ojai and who is a strong supporter of this measure. That's how this was brought to me. I learned of the death of her 20 and 24-year-old daughters who were put into a car with a known defect. That defect ended up freezing the steering wheel. The car lilted into the oncoming traffic. It hit head-on into a semi-truck. The car exploded and they were killed instantly. This shouldn't happen. It doesn't have to happen. And I would respectfully ask for your aye vote.
Thank you, Senator, and maybe we can get some brief testimony from the witnesses in support.
Okay. Mr. Chair, members, I'm Rosemary Sheehan, President of Consumers for Auto Reliability and Safety. We're the sponsors of the bill. And as the Senator noted, a lot has changed since last year. And we actually did statewide polling regarding this measure, and it polled at 88% support. And the pollsters said that the reaction that they got from consumers when they asked them about this was usually like, there isn't already a law. As most people expect when they go to a licensed car dealer that very basic things like safety recalls would be taken care of. And that's just their expectation. There's a certain level of trust there. And so they were kind of stunned to learn that it wasn't already the law. And since then, also because of what's going on with GM nationally, there's just a lot more awareness about auto safety and safety recalls and how important it is to have the recall work done. There's heightened public awareness. There's more media interest. Damian Snow was interviewed by Good Morning America. They did a feature about him. David Clayton, who Senator Jackson referred to, was on the front page of the New York Times. Media up and down the state have been covering this issue. Reporters have been going on car lots and finding recalled cars and reporting, that these are cars that have very serious, obviously life-threatening defects. Usually people have been killed or injured because of these defects, and yet they're being offered for sale, defects and all. And I'd just like to note that the bill would simply create a level playing field for all dealers. At the same time, it protects the public. And the underlying principle is that if cars are so unsafe, they can't be sold as new, and the manufacturer prohibits its own dealers from selling them as used cars, that a competing dealer shouldn't be able to do that because consumers don't understand. If you go to a Toyota dealer and you're being sold a GM car, that it might be under recall that it wouldn't be under if you were buying it from a GM dealer. And I think all of you have heard from the dealers who are opposing it, and particularly from CarMax, which is based in Virginia and took in over $10 billion in revenue last year. They're the largest retailers of used cars in the country. They represent in their ads that all their cars are, quote, certified and have undergone a rigorous 125-point inspection. And yet they told the New York Times that their inspection does not include performing safety recalls. This is totally contrary to what consumers expect when they go to CarMax. And we're planning to file a petition with the U.S. Federal Trade Commission along with other national consumer groups seeking an enforcement action against CarMax over this practice. But meanwhile, at the state level, we would hope that we could just have a bright line that says if a vehicle is under safety recall, it should be fixed before it's sold to a consumer.
Thank you very much. We'll take one more witnesses on the support side.
Good morning. My name is Damian Snow. I'm from Beverly Hills, California. I work as an actor in a TV series, and when I turned 18, I bought a used 2004 Chrysler PT Cruiser from a major franchise new car Nissan dealership in Universal City, California. It was my first car, and I thought it was a good idea to shop for a car at a big, fancy new car dealership because it seemed like they would make sure that their cars were in good condition. But it never even crossed my mind that they would sell me a car with a safety recall that hadn't been fixed. I mean, who even thinks that a dealer would do that? If I were buying it from some random guy on the street, then I would have been more cautious. But you expect a dealer to be more responsible and to check out their cars and take care of anything like a safety recall. In fact, Chrysler had issued a safety recall on my PT Cruiser in 2004 because it had a defect in the power steering hose that could cause it to leak, leading to an underhood fire and loss of steering. This is the exact same safety defect that killed two sisters, Rachel and Jackie, near Santa Cruz only about a month after the recall was issued. They were just 24 and 20 years old when the PT Cruiser they were riding in caught on fire, they lost steering, and crossed over the median, hitting an 18-wheeler head-on. If having such a horrendous, totally senseless tragedy happen is not enough to send car dealers a message they need to take safety recalls seriously, I don't know what would. But according to Carfax, after Chrysler issued the safety recall on the Peachy Cruiser I ended up buying, and after Rachel and Jackie were killed by the same defect, 3 California new car dealers, a Chrysler dealer, a Toyota dealer, and a Nissan dealer each owned it. They also leased it or sold it to other consumers. Any one of those dealers could have checked the recall status and made sure that safety defect was fixed. But either they didn't bother to check, or if they did, they still didn't get it repaired, even though the repairs are free. So when I bought it, it was basically a ticking time bomb. And it's just sheer luck that I wasn't killed too, and that I didn't collide with a minivan full of kids. So it seems incredible to me that dealers keep insisting that they should have to fix safety recalls before they sell used cars to consumers. The very fact that they're opposing this bill is evidence that it's really needed. So unless you vote for SB 686, car dealers in California will keep on playing recalled car roulette with people's lives. So I urge you to change the law before it's too late for someone else. Thank you.
Thank you very much for your testimony. Other witnesses in support of the bill, name and affiliation, please. And
Mr. Chair, John
testimony.
Moffat on behalf of Enterprise Holdings, Enterprise Rent-A-Car, in support of the bill.
Thank you very much.
Richard Oliver with the Consumer Federation of California in support.
Thank you.
Hi, my name is Angela Davidson, and this is my daughter, Kyra Davidson. Sorry. We recently bought a 2010 Dodge Ram truck on May the 19th that actually caught on fire with me and my daughter inside of it. We barely escaped with our lives. The reason that we went to CarMax to purchase the truck is because they advertise that they have expert mechanics who check all their cars, and every car has passed 125 plus point inspection. So we went there trusting that we'd get a safe car, not knowing that it had a recall for the pinion axle on it. And that recall actually was issued in July of 2013, wasn't fixed. On May 30th is when the car caught on fire with my daughter and myself and my husband in the car. So we ask that you please pass this bill. Thank you.
Thank you very much for your testimony. Other witnesses in support, name and affiliation briefly, please.
Nathaniel Kiger on behalf of California Public Interest Research Group, and we support this bill.
Thank you.
Joe Rideout on behalf of Consumer Action in strong support of the bill.
Thank you. Any final witnesses in support? Witnesses in opposition, please, if you take a couple witnesses at the table. Go ahead and begin when you're ready.
Good morning, Madam Chair, or Mr. Chair, and members. Cliff Costin on behalf of the California New Car Dealers Association. Regardless of the recent amendments made to the bill, we remain in strong opposition. For the record, new car dealers do not want to sell unsafe vehicles to consumers. In fact, our business model is made up of repeat customers, customers who come back to have their vehicles serviced, customers who come back to come get parts, and customers who come back and then get their next vehicle from the dealers. Selling unsafe vehicles is exactly opposite of our business plan. The problem with this bill, however, is that it is so fundamentally flawed that dealers cannot comply with its mandate. For example, SB 686 creates an impossible standard for dealers to meet when attempting to learn of when a vehicle offered for sale is subject to an open recall. Because the bill creates a should-have-known standard, dealers as licensees of the Department of Motor Vehicles will be held to the highest possible standard of knowledge. This effectively means that a dealer must constantly check the recall status of the vehicles offered for sale, even though that they have checked the manufacturer's website, commercial databases like Carfax, NHTSA's website, if they have any information on there, and any other reliable source to learn whether of the vehicle's recall status. Even if the dealer checked last month, last week, yesterday, or an hour ago, if a recall is announced between the time the dealer last checked and when the sale is complete, the dealer will be held to the should-have-known standard and will be subject to enforcement action by the department and lawsuits under the Unfair Competition Law and the Consumer Legal Remedies Act, with no effective way to protect itself from legal liability. This particular standard is troublesome, as NHTSA's website, the manufacturer's website, is not yet operational, nor do all manufacturers have to provide this recall information on their website. Let me say that again. Not all manufacturers have to put recall information on their websites. Last year, this committee did, at great length, debate this bill, and two key problems with SB 686 were raised repeatedly. Despite the recent amendments, nothing has changed from last year with SB 686. The first problem expressed by this committee was that the bill did not distinguish between minor and serious recalls. Not all recalls are alike. Safety recalls, as Senator Jackson mentioned, vary. Some involve steering and braking issues, while others involve software glitches, door jam stickers, and misprints in the owner's manual. We went at great length last year discussing those differences. In the last 18 months, 42 million vehicles have been recalled. This is a dramatic increase over previous years. This increase is not because vehicles are more defective, no, but instead is a direct result of the auto manufacturers who have changed their approach as it relates to recalls for fear of exposed liability, criminal fines by the government, and potential harm to the manufacturer's brand. What we are seeing at car dealerships is what used to be called a service bulletin is now being called a recall. Treating all recalls alike doesn't make sense, as only 9 to 10% of all recalls are so serious that customers are told to stop driving their vehicles. However, SB 686 still fails to make any such distinction and treats all recalls alike. Now let's go to the second problem raised by the committee last year, and that was not that NHTSA's website was not operational, it was that the bill was not a comprehensive solution to all recall vehicles. In fact, as the author mentioned, rental car companies are still excluded when they rent vehicles. So let me give you guys a scenario. Under this bill, if a dealer has a vehicle that they know is subject to a recall and the parts are not yet available, the dealers have two options. The dealer can either, one, hold on to the vehicle until the part becomes available and every day lose its capital investment as that vehicle sits on their lot as they're waiting for parts. These parts often take many months to now potentially over a year. We've seen that with the Jeep Cherokee recall. Or the second option that dealers can do, they can wholesale that vehicle on an auto auction, where a rental car company can go out, purchase that vehicle, and then proceed to rent it to you and I. This is exactly the reason why any recall mandate should include both dealers and rental car companies. But with the recent amendments, SB 686 moves further away from a comprehensive solution. But a comprehensive solution is available at the federal level. President Obama has introduced the Grow America Act, which is his $302 billion transportation omnibus proposal to reauthorize funding for highways and bridges that are set to expire by the end of September. As part of the Grow America Act, the President is proposing to prohibit the sale and rental of all recalled vehicles until repaired. We believe this more comprehensive approach is appropriate, as recalls are a national problem and deserve a 50-state solution. Furthermore, the President provides NHTSA with the authority to regulate this recall mandate. And we believe that through NHTSA's regulatory process that they will make the appropriate distinction between serious and minor recalls. It is NHTSA who is the expert as it relates to vehicle safety and can determine whether a vehicle poses imminent threat to the driver and to the passengers. While we believe that any recall mandate is premature because of this pending litigation, legislation, for this reason and all the other reasons stated, we respectfully request your no vote on SB 686. Thank you.
Thank you. We've got about 3 minutes left for additional witnesses in support, or in opposition, in opposition.
Mr. Chairperson, Assembly members, Tyler Kidd from CarMax Auto Superstores in Richmond, Virginia. As has already been stated, we sold over 500,000 cars last year. We have 18 stores here in California, over 130 nationwide. We sold tens of thousands of cars here last year, and every single one of those underwent our 125-plus point inspection and came with a clean title guarantee that they weren't flood, frame damaged, or salvage titled. We also give our customers an auto check report that indicates the vehicle's history, among other things. I just have before me the comment that we provided to the New York Times, and Ms. Shahan represented that we said we did not fix recalls. That's not correct, and it's nowhere in the statement in which we provided them. We do our best with a system that is broken. That system hides whether or not the recall is out there from the dealer, because as of now, we have to call a dealership down the street who's also a competitor, give them a 17-digit VIN and say, hey, does this thing have an open recall on it? We have to rely on them to enter that information accurately and provide it back, and then hope that that competitor will fix that recall for us. That system is broken. The bill also does not fix the General Motors problem that we've had recently. That problem relates to the manufacturer delaying announcing any recalls, and there's a fix for that in Congress right now by Senators Blumenthal, Nelson, and Markey, which would remove the $35 million cap that NHTSA can fine the manufacturers where they unnecessarily and unreasonably delay the announcement of a recall. If you want to fix this problem, you'll support that federal bill, and you'll give dealers the right to repair these recalls so that a company like CarMax isn't relying on competitors down the street to fix them. Our technicians would love to fix these recalls, but first we can't get access to the information. Even if the database or the manufacturers start providing that in a format that we can get, we still can't get the parts or the technical data. That does not benefit consumers. If you want to help those consumers, give dealers across the state that have qualified technicians the right to repair those vehicles, because then you can either have only GM manufacturers repairing those recalls, which will slow that process down, or you'll have every dealer in the state fixing those, so they'll be fixed much more efficiently and better, and you'll get those cars off the roads that much faster. For these reasons, we think SB 686 is significantly flawed, and we would join the New Car Dealers Association in asking you for a no vote. Thank you for your time.
Good morning, Mr. Chairman and members. Billy Doring, representing the Independent Automobile Dealers Association of California. I can't believe how much I can support Rosemary and also the Senator on the fact of safety. We should sell everything that's safe. Also, just like a car has to be smogged before it can be sold, we think that the recall should be repaired as well. The difficulty is sometimes getting the data, and Mr. Laskowski, our executive director, has some facts that he pulled up trying to get that. And also, dealers only sell 40% of the cars. So that means the other 60% of the people can get notices, just like Ms. Sheehan could get a notice for a repair and not fix it and sell it to somebody else. If you're going to be safe for everybody, everybody should be included in the same thing, not just dealers. We're the minority. And again, we support the part of the safety and the sale, but we oppose the bill as it is.
Thank you. Briefly, please.
Larry Laskowski, Executive Director for the Independent Auto Dealers Association. It's pretty clear that our position is in agreement with Senator Jackson that the recalls should be addressed. However, there really isn't an effective means to do that. The Bill 686 provides an extreme increase in the liability to the dealers because he cannot prove that he has done his due diligence. As an example, by going to the manufacturer's websites if you had an Audi, and I did some random sampling. I spent hours putting in random VINs to come up with these statistics too. This is what you get when you print out the actual results on an Audi. It's a blank page with an Audi logo on it, although when you're viewing it on the computer, you see that the results, in the case that I entered, it showed that there was no recall for the vehicle. However, because it displays in a flash player, it will not print. So this is the proof that a dealer would have saying that he actually did his due diligence. I entered in one for a 2007 Ford Explorer on the Ford website, and it shows me that it's a 2007 Ford Explorer, but it does not copy the VIN over to the results page, although it showed me that there was no recall for that vehicle. The liability that dealers have as a result of consumer attorneys targeting them for minor things, especially things that are unprovable, has just gone off the chart. And we would ask that some measures be taken to address these problems that we have. And I would say that the thing we need to remember, the common attorney catchphrase, if it's not in writing, it didn't happen. And that's really what this is here. It's like you couldn't possibly prove that you were diligent and in compliant with the law, and we see that as a major problem. Additionally, the same media exposés which brought attention to the unaddressed safety recalls, even after an implementation of 686, if it was to pass, we would still have the same media exposés because not all of the vehicles would be addressed. So the same reporters could go to the same lots and find some vehicles that still were being sold without the safety recalls being taken care of, yet that could be measured as compliance with 686. So I would respectfully ask that that you have a no vote on this as addressed by the senator. Thank you.
Thank you. Witnesses in opposition.
Mr. Chair and members, Scott Governor here on behalf of the California Financial Services Association. I apologize for not getting my letter in on time. We are opposed, albeit for slightly different reasons, but thank you.
Thank you. Additional witnesses in opposition.
Good morning, Jennifer Barrera on behalf of the California Chamber of Commerce. And despite recent amendments to the bill, we still are strongly opposed and have maintained the job killer status on this bill.
Thank you. Any other witnesses in opposition? Member comments? Mr. Dickinson.
Mr. Chairman, thank you. I just have a comment, not a question. I just want to express my disappointment with the approach taken by the car dealers to this legislation. And I don't want to go through each argument made. I'm sure the author will do so in her close. But let's just talk about a couple of these things. We might have to wait too long for parts. So what do we do instead? We sell a car that's unsafe? No dealer is going to do that I know that's reputable. So that our argument would seem to fall of its own weight, because the choice is between making sure a car is safe to sell or sell an unsafe car. And I can't imagine anyone who is reputable making that latter choice. The information is not available to us. NHTSA has concluded that they don't need a comprehensive database that they manage and control because the information is so readily available through the manufacturers. And to suggest that the information can't be obtained, it just flies in the face of reality. Even years ago, one could obtain by going to third-party service manuals, technical service bulletins, and recalls on vehicles. You could walk into the auto parts store and get a Chilton manual that would have that information in it. We're far beyond those years. We have to constantly check to see if there's a recall that's been opened. Sure, you have to take what's reasonable and necessary steps. It's a negligence standard. It applies throughout many things we do in life. And it is documentable by making notes in a file. Happens all the time. Every dealer has a sales file on every new and used car. These are not difficult things to overcome. And they are not reasons to not protect the public from getting unsafe vehicles that could cause injuries or fatalities. Finally, to wait for Congress, I know, is a fashionable argument. But waiting for Congress, I think, we would all agree in the abstract, is something not likely to produce a result anytime soon, virtually no matter what subject we're talking about. So I don't understand why, in this instance, the industry doesn't work with the author to figure out how to implement this in a way that protects the public and assures the goals that you articulated, Mr. Costa, that you want repeat customers. You want people coming in for service. You want people to feel that they can rely on their dealer. You want them to buy other cars in the future. This makes complete sense to work with the author and with your consuming public to make sure that they feel safe when they buy a car, and that we don't have, especially as we watch day after day more recalls roll out. 3 million vehicles GM recalled yesterday. As we watch this avalanche of recalls, why it isn't seen as in the interest of dealers to make sure that the public has confidence when they buy a used car. And remember who's buying used cars: young people, people who don't have the money or the resources to buy new cars, people who often face other sorts of challenges. Do we say to them that you're not as worthy as people who have the money to buy a new car? You don't deserve the same level of protection and safety as someone who can buy a new car? I hope that's not what is the message that any of us would settle for. So I hope that there's an attitude shift in this. If not today, I hope somewhere in the future.
Thank you, Mr. Dickinson.
And I'd move the bill.
Thank you. We have a motion on the bill. Mr. Costa, I'll let you respond to, if you can, briefly to Mr. Dickinson's comments, if you choose to.
Mr. Dickinson, if the bill was that easy and that simple and straightforward, then we would be in support of the bill. The problem is there are a number of problems with this bill. I laid it out. The should-have-known standard makes it utterly impossible for us to find out. Yes, there is more information out there available. I think you're absolutely right. We want to sell safe vehicles. We do everything we can to try to sell safe vehicles. But under this bill, if there is a moment that, like yesterday, when GM announced it, well, at what point did the announcement come? Did it come at 11:27 while I have somebody at the F&I desk I'm selling the vehicle 2 seconds later and handed in the keys, now I'm liable? I mean, how are we practically supposed to comply? Our issues are practically. And when we talk about the federal legislation, when we talk about the President of the United States, let's not forget that rental car companies are being excluded from this bill because there is pending federal legislation. And my comment about the President's transportation omnibus bill is that the President is in a unique situation. This transportation highway fund is going to run out of money by the end of September. Congress has to do something, or highway maintenance funds are not going to be available to the states. So the President is in a unique situation to provide leverage on Congress to say, you guys want projects and roads to be repaired in your districts, I want a recall mandate passed. It's different than a standalone Boxer Schumer bill. So we believe, for the moment, that it is premature for us to do anything until Congress has either acted, and if it enacts, then I'm sure we'll be back here next year.
Thank you, Mr.
Mr. Chair, may I respond to that, please?
Yes, Mr. Hagman has a question, so I was thinking maybe you would let.
Well, I think it's appropriate here because the discussion is pinpointed on two issues, and I think they have to be responded to. And the first one is woulda, coulda, shoulda known. The bill is very specific as to the obligation of the dealer. It is to look at the manufacturers. This isn't. My frustration here is that this is not only nitpicky. If they really want to sell safe cars, they really can. It's that there is not a willingness to do this because I think we heard they want to move the iron quickly. and they're willing to put keys in the hands of people when they know or could easily have known. And that's what NHTSA did. NHTSA said, we don't need to have another place where you have to go, because if you just go to the manufacturer's website, and that's what the bill says. It doesn't require that you go to 100 different places. It also says if you go to the manufacturer's website and they do not have posted a safety recall, and there has been one, the car dealer is not liable. They get to rely on the representations made by the manufacturer's website. So this business about being sued by everybody is just not accurate. And I can tell you, we have taken numerous amendments. If we had car dealers who said we want to work with you, we would have had concerns resolved. But they're not real concerns because they don't want to be required to do this. To start talking now about what the President of the United States has called for, and I think the Assembly member was correct, hell may freeze over before anything that this President wants to be done will get done.
Thank you, Senator. I think
why do we need to be relying on the federal law when we're focusing on the state of California, and that's our job?
Thank you, Senator. I'm going to try to keep the conversation moving, and
appreciate it.
Absolutely have an opportunity to close. So
appreciate it.
Mr. Hagman.
Thank you, Mr. Chair. And thank you, Senator, for bringing this up. I think everyone on this dais wants the end result of what you're trying to accomplish here. I offered, a more practical solution last time we discussed this, last year sometime. First of all, what's the percentage of private party versus that does not get affected transfers by this bill? It's roughly 60+% more.
Yes, that's right. Consumer expectations are very different, of course, when they're buying from a private party than from a licensed dealer.
Thank you. So we were trying to say these 40% who buy from dealers should be more protected than the 60% of other consumers out there, which I think is faulty on a premise to begin with. When I go trade in my car, I think most new car dealers rather not have used cars, but they take them as trades to sell their new products. That's where they make their money. They make their money on the sale of cars, and if they're a BMW dealership, for that service of BMW, customers come back over and over and over again. And I think you're absolutely right. They love to get those manufacturer recalls, who's getting paid premium dollar to get those done if you're a BMW dealership. What this bill, I think, fails to do is the practical side of day-to-day operations. So if I take my Ford into a BMW dealership, now, first of all, my trade-in is going to be discounted because obviously they want to make a profit on it versus if I sell it private party. And now if we add this bill to the case, now that dealer's going to have to go first search the database at Ford and say, hey, there's 3 recalls are here. So he's going to take that out of my trade amount. Okay, whatever it takes the time for me to take that off, that time sitting on the car lot is money they're covering, both in the loss of capital they're doing as well as the cost of storage, insurance, and everything else of the asset. Now they take it to the Ford dealership. The Ford dealership may say it may or may not have those parts in there. It may take a month, may take 6 months, whatever the case may be before it gets done. He brings it back in this lot. It sits there for 3 months. Now a buyer comes in to buy that Ford off a BMW dealership, and they have to run it again because he's liable now. And all of a sudden there's another recall on this. The practicality side is what I'm having a hard time here. All that stuff has to be factored into my trade now. So if my trade goes down another 20 or 30%, as I'm walking in as a business person, I could get $5,000 on the open market or now $2,000 at a dealer. It's going to drive more and more of our people to take their cars to auto trade and everything else versus taking the dealer where they can make 20% off it, maybe because of the lack of, I don't want to sell it and go on the weekends, it lets people drive my car. So I think for the consumer safety aspect, we're driving people away from this because of the practicality reasons. The solution is not to say no in this bill. The solution I offered last time was I want all those recalls done too. But if there's a printout you can do at the time of sale, not only for the dealers, but for every private car transfer, that says these are the recalls from your manufacturer right now to date. Not last week, not 3 months ago, not a year ago, but today we ran this when you got transferred. Now, as a consumer, I'm notified. If it is those, quote, minor recalls, the sticker on my visor that says don't put a car chair or a car seat in front of the front car because of the airbags, and I don't have any kids, I, as a consumer, can ignore that one. If it is that the axle is bad, I can say, well, that car, I have to go spend my personal time to take it over. I can negotiate that price down from that dealer or the private party. I think what we're trying to get to here as this committee and your ultimate goal is consumer awareness of what is out there. All the stories for the testimony we've heard is people did not know they had that problem with that car because they assumed things were taken care of from a reputable seller. But what we want to do is have that consumer awareness at the time they buy that car. They know what's wrong or not wrong with that car. And I think that's a better bill to mandate that every transfer, when you to change that registration, that there's a print out there, there's a signature on that line by the buyer that says, I know what's on that date when I bought the car. Now, if it is from BMW at a BMW dealership used car, they're going to fix it all because they're getting paid by the manufacturer. But that third party, the reimbursement, is not going to cover their time to take that Ford, to drive it over to the Ford dealership with two drivers, drop the car off, come back with another car, wait for that car to be done, take it back out and back again. That's why I had a problem with the concept in the first place, not the end result. But that I think we're going to drive more people to the private market, which they're not protected, in which case it would hurt public safety. So,
thank you, Mr. Hagman. Any other member comments? Mr. Wilk.
I do.
Where do you begin?
Thank you for that, because that's one of my concerns. I got a question for the opponent and then for the author. And maybe I wrote this down wrong, Mr. Costa, but you said that I'm going to just do both questions, throw it out, and then you guys can answer. You had said that not all manufacturers have to list their recalls, so I just wanted to know what that standard was and that. And then for the author, since we are using the higher should have known standard, is that going to require a dealership to go on, as Mr. Hagman said, like literally every day to check? So I'm curious on that, because I'm concerned about safety as well, but I'm also concerned about it being practical. So if you could start, Mr. Costa.
Mr.
Sure.
Costa, if I could ask you to just respond to the member's question, and let's not get back onto President Obama and what's going on there.
Completely agreed. NHTSA's regulations, Mr. Wilk, actually said that all large manufacturers, and they deemed large manufacturers as selling more than 25,000 units nationwide or more, was required to post on their website, searchable by VIN, what the actual recall status is. So if you are a sub 25,000 unit manufacturer, you are excluded. For example, just to name a few, smart cars, Jaguars, Tesla, all the exotic cars. We're talking Aston Martins, Ferraris, Lamborghinis, Maseratis. Those are all excluded. They don't have to put. They're not required to put any information on their websites.
Thank you. And Senator, I'd ask for the same courtesy in just answering the question.
I'm going to defer to my expert on this.
Thank you.
Right, that's right, correct. And under the bill, dealers would not be liable if the information is not on the manufacturer's website. There are 3 triggers for the dealer liability to meet the standard. One is if they're a franchisee of the manufacturer because they get noticed directly. The other is if they actually received it's called Rule 577 notice. And when Mr. Costa said, when does this obligation begin? Who knows? Is it when it's announced? The bill is very clear that the obligation doesn't begin until there's actually an official safety recall. And either you're a franchisee or you got the 577 notice, or it's actually on the manufacturer's website. So we conceded that in order to be fair, that we would live with whatever NHTSA required the manufacturers to do. So if a manufacturer is not required to put it on their website, dealers can find out by contacting a local dealer if they care, or calling the manufacturer's toll-free number, but they don't have the same legal obligation. Does that make sense?
I'm still not clear. So we were talking about the earlier example, and that vehicle, that Ram, whatever, was on the lot for months. My question is this: so you take in, and frankly, I think you should check it when you take it in, but because of the higher standard, is that something where a dealer would have to actually check every day?
No, sir.
Because it's pretty common. I bought a few years ago a used BMW, and it sat there for about 3 months. And I went in, I wanted it, but I didn't want it at that price. And I kept waiting for it to go down. I kept talking to the dealer, and he wouldn't do it. And then finally, he'd been on the lot like 4 months, and then he said, "Hey, I'm going to wholesale it, so I'll give it to you for this price." And then I bought it. But so sometimes these things sit for a long time, and they pay flooring costs, and there's a cost of business to that. So I'm just curious what that standard is.
Absolutely, and I think your point is well taken that would be unreasonable to require dealers to check like every day. All the bill says is that it should be safe when it's delivered to the consumer. That's it. It doesn't specify how often a dealer has to check. That's totally up to the dealer, and it may vary depending on dealers. You know, some dealers will want to check even before they accept a car as a trade-in and say, you know, I don't want to have to hassle with this, so you go get it fixed, then, you know, bring it back, and maybe we'll be interested.
Thank you.
But as long as the car is safe when it's delivered, that's what the bill says.
I think we're quite sufficiently drilling down to all the debatable points of the bill. Are there any other comments from members? Senator, would you like to close?
Well, let me just ask.
I'm sorry. Mr. Holden.
I guess I wanted to get an idea of, and it has been talked about a lot, but in terms of understanding when cars are going to be placed on recall and when you would know about that. But there are, and currently how it operates today. You had mentioned also that if you get a car and you can't fix it, the parts aren't in time, you're not letting the car back out onto the street. So how walk me through how that works. You also mentioned that rental car companies, and that part of the reason you're concerned about the bill is that rental car companies could purchase these vehicles from dealers and then turn around and rent them out.
Correct.
So the car would be sold to the rental car company with the expectation that the rental car company would make the repairs before they rent the cars out. So I'm just trying to understand how.
Sure. What currently happens now is if the dealer is a franchisee of that vehicle, that recalled vehicle is the same make of the dealer, he will go out and if he's aware of the recall, and they have the database there with the manufacturer directly, and they'll pull the information and they'll pull it. And they'll make the recall repair if the parts are available. If the parts are not available, then the dealer presently still has two options. He can either wholesale it and sell it to somebody else. Now, you mentioned rental car companies. I mentioned rental car companies. Rental car companies as a dealer can purchase vehicles at auction. So that is what my scenario was about. Another dealer, they can wholesale it out of state. They can go anywhere else. So that's typically my understanding what happens. If it's a manufacturer or it's a make of a vehicle that the franchise dealer is not actually a franchisee of, they presently don't always know that the vehicle is subject to a recall. And that goes back to sort of what our concern had been about the should have known standard. And I just point you to page 2, line 17 of the bill, which says that if the dealer knows or should have known of the vehicle was recalled. So I hope I'm answering your question, Mr. Holden, but under this bill, it's possible that two things are going to happen. If you come in and you want to trade in your vehicle, and I say, okay, Mr. Holden, I see here I have now, because I've looked and the manufacturer actually has information on their website, I see you have a recall here. I've called over to the Ford dealer, and the Ford dealer says the parts are not available. So you can go ahead and trade that vehicle in, and I would have offered you $7,000. I'm now going to offer you $2,500 for it. Or you can choose not to trade in your vehicle. Then you are left with a choice. I can either sell it or trade it in to the dealer for $2,500, or I can sell it on the private market, meet up with somebody at Carl's Jr. and sell it to them for $7,000. The question we have continuously raised in this committee last year and now this year is what's the policy objective here? If the policy objective is we are worried about these vehicles that are completely unsafe and they're driving the road and they're going to harm me as a driver and you as a driver and other cars on the road, then shouldn't we try to get as many recalled vehicles off the road? And if that's the answer, then including rental car companies, talking about the private market, and including dealers is the approach. However, Senator Jackson's bill has gone the opposite direction. So I don't want to repeat myself, but that's our concerns. Those are our arguments.
Could we let the rental car companies respond? I kind of feel like that we're not getting both sides of the story here, and it is my bill. So I'd like to be able to present. And if we could, the rental car companies are here, and they are in support. So if we could let them respond to the Assembly member's question.
Yeah, and I know you're trying to wrap this up, Mr. Chair. I just want to be very clear. We don't buy used cars and rent them. We buy new cars from the manufacturer that go into our rental fleet. Once they're done with our rental fleet, we'll either sell them at auction, or Enterprise and other rental car companies are also licensed dealers in the state of California, and we will sell those vehicles at retail. We do not rent vehicles that we would buy potentially used vehicles. Doesn't happen. We rent new cars. We sell used cars. And because of that, this bill applies to us the same as it applies to these folks.
Can I just jump in here? Because I think I need to ask Mr. Moffitt to clarify that he's only speaking for Enterprise Rental Car right now, not all rental car companies. Is that correct?
No, we have a joint letter into the committee that
I think the point that I'm specifically pointing to is when you state that you don't buy cars and rent them, you're speaking for Enterprise.
Yes.
There are rental car companies that do buy used cars and rent them.
I cannot speak to that.
Okay,
I can speak to Enterprise.
Okay, I just wanted to make sure you were clarifying that you were just speaking for Enterprise at that point in time. Thank you.
But it is clear that the rental car companies are prepared and support the notion that they can't sell used cars.
Right. I just wanted to make sure that we're being as factual as we can be.
Right. And we need to be as clear, because the rental car companies support this. They are on an equal, they're going to be held to the same standards. The only ones who aren't supporting this are the car dealers. But the rental car companies, when they sell used cars, are prepared to comply, and we haven't heard them creating the same issues about liability and so forth, because, in fact, in response to the witness's testimony about known or should have known, if you go to page 3 of the bill and you look on lines 5 through 20, it articulates when a dealer is supposed to know or should have known. It defines those limitations very clearly. So, again, let's focus on what the bill does. And if the car dealers really want to sell safe cars, then this bill allows them. It gives them the roadmap. And again, the goal is to have a car safe when it's delivered to the consumer, and that's what this bill does.
Okay, thank you. We have a motion on the bill. I'm sorry? We have a motion, not a second. So is there a second for the bill?
I believe Assemblymember Skinner would, if she were present. So can we just hold this to get a second on the bill?
I'm sorry? Okay, Mr. Ting seconds the bill. We have a motion and a second to, I believe this is going to Judiciary. Next, Senator Jackson, would you like to close, please?
Yes, I thank you for the robust discussion. I find myself a little frustrated here. No bill is perfect. We have taken several amendments. The goal here is to make sure that when a car gets into the hands of a consumer, it is safe. We can't do it, I would submit, in the situation of all purchasers. It would be wonderful if we could, but we can do it with licensed car dealers. We can hold them to a particular standard, not only because we license them and therefore have some regulatory controls, which we don't have over someone who's doing a transaction at a Carl's Jr., if you will, a one-on-one, but also there's a public expectation. And it defies my understanding that a new car dealer or that a car dealer would not want to get the public trust that is associated with assuring the public that they are selling cars that are safe to drive off the lot. The notion that they don't have to look or shouldn't have to look before they sell a car kind of plays into, I think, what is a public perception that car dealers are not trustworthy, even though the public wants to think they are, even though we want to think that the person selling us a new or a used car from a car dealership is a trustworthy person. And I can tell you, this past weekend, my husband went out and bought a 2013 used car, relatively new car, and I spent about 10 minutes at the dealership, and I asked the car salesman, who was now becoming my husband's best friend. I'm sure that's part of the whole thing. Going to show my husband how to use all the bells and whistles, and I believe hell will freeze over first. But I was quiet about it because that's what he presented. He would do that. My husband was thrilled at the notion. He'd made a new friend. And when I asked him whether or not in this spectacular certified 125-point check, whether or not they checked to see if the car was under a manufacturer's recall. And the salesman said to me, well, of course we do. It's required by law. And I said to him, no, it isn't. It is not required by law. You're selling a 2013 as a used car. It is not required. He said, well, of course it is. And I assured him it was. And he said, but it should be because it's a question of safety. And I said, yes, you're absolutely right. And I think that basically, here's a car, and the one condition that I gave my husband in buying that car, I said, whatever you want to do, but you have to make sure that that car has gone through a manufacturer's recall check. And he did show me that it had, and so I feel better about the car. But my point is this. Car dealers want to sell cars. They want people to trust that they're selling them a proper car. They want to trust that when they're told the car has been through a rigorous 125-point check to make sure it's safe, that if there is a place to go to determine whether that car has a safety recall, not whether the air conditioning is working, but a manufacturer's safety recall, they are entitled to know that that is in fact what has happened. And because NHTSA has now said, manufacturers, you are obligated to make that information known on your website. There is no excuse now for a car dealer not to do that. And I think I mentioned my own experience when I was looking for a new car about a year and a half ago. The car salesman, we're sitting at his desk, he clicks on with his computer to the place where you can get custom colors for your car. He wanted to show me that. And my thinking is, if he's willing to do that, something that isn't necessary to the safety of the car, how about just having him click on the VIN number to see if this car would be safe to drive off the lot? And that's basically what we're asking for here. This is, could we go to minor companies? Let's start with what we can do. Let's start with what we can do, and we can say to the major car manufacturers and the car dealers, we want to make sure that we do not put cars on the road here in California that we know are unsafe. And with that, I would ask for your aye vote.
Thank you, Senator. We have a motion and a second. If the Secretary can call the roll, please.
Bonilla? Jones?
No.
Jones, no. Bocanegra?
Not voting.
Campos?
Not voting.
Dickinson? Aye. Dickinson, aye. Eggman? Gordon? Hagman? No. Hagman, no. Holden?
Not voting.
Mainshine? Mullen? Skinner? Ting?
Not voting.
Wilk?
No.
Wilk, no.
Senator, you have one aye vote, some members absent, and some not voting. It'll be on call.
Thank you. And if the bill fails, I'd like to request reconsideration.
Thank you.